Hi, you're here with Kevin Vitali from Real Broker and Rick Carter from Carter Closings. And today we're going to talk about the purchase and sale agreement and why it's important for buyers and sellers. So, Rick, I've known you for about 20 years. Why don't you tell me a little bit about yourself? You're primarily a real estate conveyancing attorney who represents buyers and sellers. What else should we know?
That's pretty much I do. Yeah, I represent buyers, sellers, and lenders in Massachusetts and New Hampshire for residential closings. I've been doing it for probably over 35 years now.
Uh-oh.
And that's all I pretty much do. I'm considered a transactional attorney. We just do closings again for buyers, sellers, and lenders. So that's it.
Well, and I think an important note that everybody needs to realize is that when you hire an attorney, they should be a real estate attorney. So at least 35% of their business should be made up of real estate. Rick and a lot of attorneys I work with, that's all they do is real estate. And I think that's important when you might have a family friend or a family member that's a tax attorney, but you're not going to understand real estate law. What are your thoughts on that, Rick?
Yeah, I'll definitely, especially on the buyer side. I mean, a bankruptcy attorney or a divorce attorney, they're not going to have the systems in place to get closings done. They're not going to have the software needed. They're not going to have the contacts in different registries to get title searches done. Um, they're probably great at their particular field, but this is a very niche market where, yeah, you definitely need a real estate attorney involved, a residential real estate attorney. Yep. Exactly.
Well, and I know since I've known you, real estate is very dynamic and how you do things changes quite frequently. Like the purchase and sale today is very different than the purchase and sale 20 years ago.
Oh, absolutely. And I see the changes and the contingencies over the years too. Things that we seem to worry a lot more about these days, like building permits, things like that. 25 years ago, no attorneys ever brought that up, which was still just as important then. Yeah, I definitely see fluctuations. Radon used to be a big thing. I don't see that contingency in there as much as it used to be. So yeah, it's just there's an ebb and flow. There's the main ones that you always have to have in there. But yeah, the kind of the collateral ones seem to be changing over the years. Yeah.
Well, well, what I notice recently is the attestations that a buyer's attorney is making the seller make. We never used to have those. Now it's just down to the nitty gritty, you know.
Exactly. Yeah.
And so it is important to be represented by an attorney, whether you're on the buy side or the sell side. If you're closing a loan, you're going to need an attorney. But as a seller, it's optional to have an attorney. But I think it's very important that you have an attorney at least represent you in getting a purchase and sale negotiated with the buyer.
Absolutely. I think on the buyers end, I've seen that change over the years because, and I'm sure we'll get to it. There's relatively few disclosures a seller has to give in Massachusetts, and I'm sure we could talk about those. But one exception is to the lack of disclosures is that a seller needs to honestly answer any questions a buyer may ask of them.
Mhm.
So, as a part of the due diligence period process. Buyers then, with that exception in mind, ask the sellers a lot of questions about the property to help out in their due diligence. And since the seller is required to honestly answer, I am seeing that a lot more in purchase and sales, a lot of representations in there.
So let's circle back for a second. I think it's important to note Massachusetts is what's called a caveat emptor state, which means buyers beware and sellers do not have to provide any disclosure except for a few things like lead paint and private sewer system in Massachusetts. Most states actually require a seller's disclosure. Am I correct in saying that, Rick?
Yeah, absolutely. Massachusetts seems to be well, I don't know all 50 states, but yeah, there's a lot less disclosures required in Massachusetts. Like at this point during our conversation, at this point in time in Massachusetts, you wouldn't necessarily have to tell a buyer that you think the house is haunted or someone was murdered in the house. Whereas other states might require you to do that.
Mhm.
And
I,
again, the
you
exception
can
to
go,
that is if you're ever asked something like that, you'd have to say honestly, give the honest answer. But yeah, Massachusetts is you're not required to make certain disclosures like that.
so let's get into the purchase and sale.
Yeah.
What is a purchase and sale contract, Rick?
Purchase and sale. Well, let's back up a little bit. In Massachusetts, which is also different than some states, we have what's called a two-tier process.
Correct.
So there's an offer originally signed between buyer and seller that memorializes the important terms of the agreement, and then from that stage you jump into the purchase and sale stage, which usually is a little bit more involved, but still has the same material terms, but may have certain representations, like we're saying, a buyer's attorney is looking for sellers to make. So that's what it is. There's an offer sign and then the jump into the purchase and sale.
So when you say offer, I think most people will see the paperwork as contract to purchase,
Contract to purchase,
and
right.
that is considered the offer, which I think it's important to know, and tell me if I'm wrong. An offer in most states are not legal and binding. They're more like a letter of intent, where in Massachusetts, it is a contract and it is legal and binding. But what you are agreeing is to go to a bigger contract that spells out the details. Am I correct in
Right.
saying that?
Right, right. An offer, yeah. A lot of people, you're right. A lot of people offer think an offer is just kind of like the stepping stone to get to the purchase and
Loosey
sale.
goosey.
Exactly, exactly. But no, the offer is, I mean, if an offer gives the material terms, it's in writing, and there's an intention to have the parties bound to that agreement. That's a binding agreement. So if a seller doesn't go through with a sale, but has signed an offer, then they could be subject to certain legal claims against them.
Okay.
Yeah.
So we talked about the contract to purchase, which we're going to loosely call the offer. Then you go to a bigger contract, which, the standard contract, purchase and sale contract used to be about 5 pages, but I see them being up to 12 to 20 pages now by the time the attorneys get hold of them and add the language that helps protect their buyer or seller in the process. Um,
Right,
so
right.
so the important thing I think we need to know is that the both contracts, but specifically the purchase and sale is legal and binding, and the terms are enforceable that are in the contract that you actually sign and agree to. Could you speak on that a little bit?
Yeah, I personally think the purchase and sale is the key to the whole closing. If everything's set out correctly in that purchase and sale, it should be between the parties, it should be pretty much clear sailing to the closing table. I always get buyers and sellers surprised at closing that we're really only at the closing table for about a half hour. And that's only to go over the forms for the closing. For the lender has certain forms, things like that. But at closing, if there's a properly drafted purchase and sale, there should be no hiccups along the way between the parties. Of course, there's other hiccups that come along, but everything should be clearly spelled out in that purchase and sale. Everything, mortgage financing dates, inspection, any clauses should be in that purchase and sale. I think that'll make a clear sailing to the purchase. I'm sorry, to the closing. And related to that, I always think that not only buyers and sellers should be reviewing that with their attorneys. I actually think agents should be looking at the purchase and sale, and buyers, lenders looking at the purchase and sale, just to make sure nothing's slipping through the cracks.
Well, as someone who represents buyers and sellers, I do review the purchase and
You
sale,
do, yes.
and specifically because a seller or a buyer might not quite understand the importance of the purchase and sale, but we're talking the difference. Someone can say something, and while it's a verbal contract is legal, it's not enforceable because there's no proof. So basically, if something's important, it needs to be in that purchase and sale contract. And so,
Exactly.
there might be an agreement that a room gets painted or, a
Exactly.
chimney gets repointed or something like that. If it's not in the contract, it's really not going to be enforced.
Exactly. So usually when there's any issues, it's not on the big things. Usually everyone has agreed to the closing date. Everyone agrees to when they should get their financing. Everyone has agreed to the terms, the purchase price. The hiccups I usually see is the little things. A seller has forgotten to tell everyone or tell the attorneys that they wanted to remove the chandelier, and that wasn't put in the purchase and sale. So, there's a question at closing. So that's why it's very important. Sometimes as attorneys, we just don't know what has been verbally agreed to between buyers and sellers. I had a closing a few months ago where halfway during the closing, the buyer says to me, "So what is the seller doing about that knob and tube wiring?" I said, "What about the knob and tube wiring?" He says, "Oh, they agreed to remove it before closing." But that was the first he had told any of the attorneys, and I'm sure the agents must have known, but we didn't know anything about that. So if there's anything like that, it's got to be in the purchase and sale, or the seller might not have to, comply to that condition. Yeah.
My very first real estate deal, what, back in 2001, 2002, something like that, was actually someone I knew from a prior business. They had hired me to be their buyer's agent, and we went to do the final walkthrough. And in the purchase and sale, it said the stove and the microwave were staying, but the seller had actually ripped out the microwave, not neatly either, and also taken the stove. And it became a big issue. I just went back and forth, back and forth. So then finally, the seller agreed to bring back the stove and the microwave and reinstall the microwave. I'm following them back to the house. The stove falls off the back of the truck and smashes. And then it became an issue of how much were the buyers going to get reimbursed. They were like, it's an old stove, it's
Oh
used, da,
boy.
da, da,
Yeah.
da. And it was a nightmare. But it was stated in the purchase and sale that the
Yeah.
house was being delivered with a stove.
Yeah. Exactly. Oh, I could tell you a million examples too.
Yeah, no, I know. I think it's important that, and I get, you've known me for a long time. I do a lot of blogging on real estate. I come out with a major article almost once a week, and I get a lot of phone calls about people wanting to back out of a deal or feeling like the seller or the buyer is not completing their obligations. And I'm just like, it's all in your purchase. Most everything that's important is in your purchase and sale contract. And I think it's very, very important. They can be long, they can be boring, but take an hour, read the contract so you understand the basic terms. And if you don't understand it, ask your attorney so they can explain it to you.
Absolutely, because most issues that you're going to have are should be clearly stated in the purchase and sale. I had a,
Absolutely.
I was representing the seller, and the buyer said, "Well, I'm not paying. Oil prices are shooting up to the roof, so we had a buyer say, "Well, I'm not going to pay a fuel adjustment." Because we had delivered the amount that's owed, that's still in the property and the value of the. So he says, "I'm not paying it." But the purchase and sale says you're in default unless you pay it. I had another. I was representing the seller, and the buyer says at their walkthrough, "There's a hole in the closet. You got to fix this." And there's language in the purchase and sale that speaks to that. She waived her home inspection. The hole was in the property when she signed the offer. So the purchase and sale says it's just going to be in the same condition as it was when they signed the agreement, accepting reasonable wear and tear. Right. So everything should be included in that purchase and sale.
Yeah, I think if a problem arises, most likely it's addressed in the purchase and sale.
Right.
And it shouldn't be a surprise to you if you've actually read your purchase and sale.
Exactly.
So, so
And it
that
should
kind
be.
of, go ahead. I'm sorry.
Oh, I'm sorry, but and we got to make sure the language is in the purchase and sale covers the whole situation. So I'll give you this one last quick example where there was a real problem at closing after the buyer did their final walk through the property. He found out that now his whole backyard was no longer usable because of the septic system that was put in. So the purchase and sale said, all right, seller's going to replace the existing septic system, put in a new system. they never really agreed upon what the septic system was going to be.
Well, so one of the things from me being a buyer's agent or even a seller's agent, I want the seller to know exactly what's going on with the septic system so we can tell a potential buyer. But as a
Exactly.
buyer who might be interested in a home with a failed septic system, we write in the language that the final design needs to be approved by the buyer. You don't know, is the backyard going to be right next to you, North Reading? North Reading is famous for these systems that are 4 or 5 feet higher
Exactly.
than they
Yeah.
originally were, and you
Right.
end up with
Right.
like this Indian burial mound in your
Right.
backyard. And so language is very, very important. And I know you and I have had this discussion. You need to be very specific about what you want and what you intend. But then you and I have talked about words like may, shall, will,
Right.
and they all have a slightly different meaning and legally, and that's why you
Yeah.
need an attorney.
Exactly. Yeah. No, you're right because one statement to one person might mean something else to the other person. So you just got to be as concise as possible. That's the whole art of doing a purchase. Someone says in the agreement, yeah, we're going to repair the, pillars in the basement or whatever it is. What does that really mean? How you're repairing it. So you got to be as very specific as
So
possible.
that leads me to, I had a situation where someone had a list of about 10. They were kind of like little items needed to be done, but they didn't specify it needed to be done a certain way or by a
Yep.
licensed professional. So I
Yep.
always write in, the work needs to be done by the appropriate licensed professional with receipts provided.
Exactly.
Like my client repaired the items, they just didn't do the nicest job in the world. And then,
Right.
now you're in gray area
Right.
about so being specific. So that this goes to let's talk about so a lot of people think, purchase the terms in the purchase and sale are a moving target. And, they'll say, oh, well, I want to move up the closing date, 3 weeks after they sign the original contract. And let's talk about, can you change a contract after it's been signed?
Yeah, you can always change a contract as long as it's agreed upon by everyone. So you
Yeah,
just can't.
someone could say a seller says, no, I don't want to move the closing date, and you can't meet that date, and things aren't handled properly. Technically, you're in breach of contract.
Exactly, exactly. And the other the other caveat to that is if the parties do make a change in the agreement, you got to let everyone else involved know, like a lender. So if now the closing date's a week beforehand, sometimes buyers just don't tell them. Although it seems to make common sense, you let the lender know, or if the purchase price is changing, you got to let the lender know that because they got to qualify you in completely different terms, or if the seller is now giving you a closing cost credit because of the home inspection repairs, you got to let the lender know that. So yeah, so to answer your question, yes, things can be changed if everyone agrees to it, and if they are all agreed upon, you got to let everyone know about those changes.
Yeah. So that leads me to so can you just back out of a contract after signing it? And then so you and I both know that backing out can be a big deal unless there's contingencies that allow you to back out. So if you could touch upon that briefly, about being in breach of contract and then, what a contingency is. I
Yeah,
see a contingency as an if then scenario. If this happens, then this happens. If it doesn't happen, then this happens.
right. Yeah, exactly. So on a buyer's end, what they're trying to do is get as many contingencies in the agreement as possible to allow for those outs. A seller obviously wants as little contingencies in the agreement, so the buyer doesn't get their outs.
So
So
let's circle back with a contingency when you have so common ones are getting a mortgage by a certain date or having a home inspection by a certain date.
yeah,
And so like say you don't get a mortgage by a certain date, you can back out of the deal and get your escrow money back as long as it's done by the terms of the contract. Correct?
exactly. And
Okay.
you have to comply with the terms of the contract because the terms of the contract are going to say, all right, if we don't get this financing by November 15th, we can get out of the deal. But it also says what the terms of the mortgage that you're applying for. Did you act diligently to get the mortgage? Did you change the mortgage amount? Did you act reasonable in getting all the documents? So you got to comply with whatever the terms say in that purchase and sale. Then, if you comply with them and notify them in a timely manner, potentially you can get your money back. Now, that's probably the biggest contingency that is ignored by a buyer. They never check to see what their financing dates are. You and I check them on behalf of a buyer, but buyers never seem to check that on their own. They don't know how important that financing date is. So, to answer your question, if they've done everything they're supposed to have done and notified them in a timely manner, they could potentially get their deposit money back. Yeah.
Okay, so let's talk about what if they don't. I mean, I remember when I was a mortgage officer, I was at the closing table, and the sellers were getting a divorce, and the wife refused to sign the paperwork to sell the house. So now the buyer is in breach of contract. What does that really mean? Just like,
Was the
actually,
buyer
it's very different for a buyer and a seller, but for a buyer, if they breach a contract, what does that mean to them?
so that you mean the seller was in breach, right? Or the
No,
seller?
the buyer. Oh, I'm sorry. The seller was in breach. Correct.
Yeah,
Uh,
okay, yeah, yeah.
yes.
So if a seller doesn't comply with the terms of the agreement, they can be sued for a cause of action called specific performance on the deal. So in other words, the buyer could go to court and say, "Listen, we have an agreement here. They reneged on it." They could go to court and say, "We want the sellers to be forced to comply with the terms of the agreement."
Not only can they be forced with specific performance, but there could be damages involved as well. Correct.
Well, it depends on what the agreement says.
Okay.
So, so if the agreement says, if you bail on us, you're going to do pay us for housing, moving costs, things like that. So, that's what, yeah, yeah. So
Okay.
a buyer when they renege, it's usually the deposit amount. And you got to make sure in the purchase and sale, there's language to that the deposit amount is what they're capped at to lose. So it should say, and this is the full amount that we're going to have to pay.
Yeah, usually it's the amount of deposit that is on the table. So, that's why a seller wants a higher deposit, and then as a buyer, you want a lower deposit. I mean, let's face it, I've put deals together on $1,000 deposit because of circumstances, but let's face it, anybody could walk away from
Right,
$1,000. It's a lot harder to walk away from $30,000.
right. And that's why we go back to the actual contingencies. A buyer wants as many in there as possible so they can walk away. Sellers want as little as possible, but buyers also want the contingency as vague as possible. Like a very important contingency when you're buying a condominium, and you do it all the time, is it's subject to the review of the condominium documents. And if they leave it at that, they could just get out of the deal whenever they wanted to, if well within reason, but they would have to have the seller would want that contingency limited to a certain time frame.
Yeah, yeah. I mean, because otherwise it could go on forever and ever.
Exactly.
Um, so I'm a real estate agent. I'm not a video producer. I forgot to record the last several minutes of this video with Rick Carter. I wanted to thank Rick Carter for being available and teaching us about the purchase and sale. So to kind of wrap up, I think the important points are the purchase and sale is probably one of the more critical pieces of a real estate transaction. It really spells out what's going to happen, when things don't go the right way. And I think it's important that both home buyers and sellers note that if you agree to something, it needs to be in the purchase and sale. If it's not in the purchase and sale, It's not enforceable, meaning if there is a dispute and it goes to the court of law, they're falling back to the purchase and sale and seeing what that has to say. So things like sellers needing to do a house repair, that needs to be in the purchase and sale. If it's not, you have no recourse. But anyways, thank you, Rick Carter. And also, as a side note, Rick Carter runs a podcast every Tuesday. It's a little different. It's called Real Estate House Party, and it is Rick Carter, his paralegal Kathy, and local comedian Tony V. And then usually there's a special guest, and they discuss real estate topics. But with Tony V on, a local well-known comedian, you never know what's going to happen. It's very entertaining. Make sure you check that out.